A trust works properly when each person understands their authority correctly. The trustee manages the structure, the settlor establishes it, the beneficiaries may receive benefits, and the protector may supervise the selected decisions. If these responsibilities overlap or remain unclear, distribution can be delayed, investments can be challenged, and control can become difficult when someone dies, becomes incapacitated, or steps away. My name is Shiraz Wahid and I'm the co-founder at Lipitus Wealth. And in this video, I'm going to explain the roles of the trustee, the settlor, protector, and beneficiaries together with other roles that may be used in a more advanced trust structure. We will look at what each person can do, where their authority ends, and how the roles should work together. A trust is a legal relationship rather than a company. So the trust deed and the laws governing the trust determines how the structure operates. Now let's start with the first role, that is settlor. The settlor is a person who establishes the trust and transfers assets into it. In some jurisdictions, this person may be called the grantor or trustor. The settlor normally defines the purpose of the arrangement, identifies the beneficiaries, and agrees the main terms recorded in the trust deed. Once the assets have been properly transferred, the trustee holds and administers them under those terms. The settlor should not continue treating the trust assets as personal property. Direct withdrawals, personal instructions to the bank, or unrestricted use of trust assets can weaken the separation that the trust was intended to create. Some jurisdictions allow the settlor to retain specific powers, which are often described as reserved powers. These may include the ability to appoint an investment advisor, add beneficiaries, change the governing law, and appoint or remove certain office holders. Reserved powers must be drafted carefully because retaining extensive control may affect the legal, tax, and asset protection treatment of the trust. The settlor may also prepare a letter of wishes explaining how the family should be supported, how education and healthcare should be funded, and how the family business should be handled. The letter usually guides the trustee without replacing the trustee's independent judgment. Now, the second role is of a trustee. The trustee is the main legal decision maker within the trust. The trustee holds legal title to the trust assets and must administer them for the beneficiaries or for the stated purpose where a purpose trust is used. The trustee must follow the trust deed, stay within its legal power, and comply with the governing law. A trustee may be an individual, a professional corporate trustee, or a private trust company. A trust may also have two or more trustees acting together. The suitable arrangements depends on the value of the assets, the countries involved, and the needs of the family and the level of professional administration required. The trustee normally controls the trust bank accounts, keep records, arrange reporting, review investments, and decides whether distribution should be made. It may appoint lawyers, accountants, custodians, and investment managers, but appointing advisors does not automatically remove the trustee's responsibility to supervise their work. A professional trustee must apply independent judgment and should not simply follow every request made by the settlor or the family. Before making a distribution, the trustee may need to consider the trust deed, the needs of different beneficiaries, available liquidity, tax advice, and long-term objectives of the structure. Where a private trust company is used, the company acts as the trustee and its board makes the trustee decisions. Family members may sit on the board alongside independent professionals, allowing greater family participation while maintaining a formal decision-making process. Now, the next role is for the beneficiaries. Beneficiaries are the people or organizations intended to receive benefits from the trust. They may be named individually, described as a group, or included family members who are born in the future. In a fixed trust, a beneficiary has defined interest or entitlement. In a discretionary trust, the trustee decides which beneficiary receives support, when support is provided, and how much is distributed. A discretionary trust, on the other hand, does not normally own a specific trust asset simply because that person is included within the beneficiary class. A trust can provide benefits in several ways. The trustee may distribute cash, pay school fee or medical cost, provide a loan, allow to use a property, or invest in a beneficiary's business. Each option can create different legal, reporting, and tax consequences. The beneficiaries may also have rights to information about how the trust is being administered, although the extent of these rights depends on the trust deed and governing law. The trustee may need to balance transparency with confidentiality and the interest of wider beneficiary group. The beneficiary's country of residence, domicile, citizenship, and tax position must also be considered. A distribution that is efficient for one beneficiary may create additional reporting or tax exposure for another beneficiary living in a different country. Now, next is the role of a protector. Protector provides an additional level of oversight. The protector does not normally manage the trust assets or make everyday administrative decisions. Instead, the trust deed may require protector approval before the trustee can take certain important actions. These actions may include making a substantial distribution, removing or appointing a trustee, changing the governing law, adding a beneficiary, or completing a transaction involving a family business or real estate. The trust deed should clearly state which decision requires the protector's consent and which decision remains entirely with the trustee. The protector may be a trusted individual, a professional advisor, a corporate service provider, or a committee. The person who is selected as a protector should understand the family's objectives while remaining capable of making a balanced decision. Appointing the settlor or a close family member may provide useful knowledge, but it can also concentrate control and create conflicts. The protector should not manage every trustee decision unless the deed and governing law clearly supports that arrangement. The trust documents should also explain what happens if the protector dies, becomes incapacitated, resigns, or need to be removed. Without an effective replacement process, the trustee may be unable to complete decisions that require protector approvals. Some trusts use an appointer as a separate role. The appointer normally has the power to appoint and remove trustees. In other structures, this is the authority given to the protector, the settlor, or the committee. Separating appointer role can create an additional governance check, particularly when trust holds valuable business interest or assets across several jurisdictions. Now, the next role is the investment advisor. An investment advisor may support the trustee with the management of trust portfolio. The advisor may provide non-binding recommendations, or the deed may give the advisor authority to issue investment directions within an agreed mandate. The trust documents must make this distinction clear. If the advisor gives binding direction, the document should explain whether the trustee can reject a direction that may breach the law, the trust deed, or the trustee's wider duties. More complex structures may use an investment committee rather than one advisor. The committee may include family members, professional investment managers, and independent advisors. This can be useful when the trust owns a concentrated business interest, private equity investments, or assets requiring specialized knowledge. Clear voting rules, conflict procedures, and replacement provisions are important in this situation. An investment role should improve the decision making without creating uncertainty over whether the trustee or advisors carries responsibility. Now, let's discuss the next role of distribution advisor. A distribution advisor may help the trustee understand circumstances of different beneficiaries. The advisor may provide information about education, healthcare, family needs, or business plans. In some structures, a family committee performs this function and acts as a formal communication channel between the family and the trustee. The committee may recommend distributions, but the trustee usually retains the legal authority to either approve or reject the distribution. This allows the trustee to consider the wider terms of the trust, available assets, and interest of other beneficiaries. A family committee can also prepare the next generation for involvement in the structure. Family members can learn how the trust operates without immediately receiving control over the assets. The trust deed and the supporting documents should explain whether the committee's recommendations are binding, how members are appointed, and how conflicts are managed. Now, a purpose trust is created to achieve a defined lawful purpose rather than to provide benefits to a named individual. It may be used to hold shares in the private trust company, preserve ownership of a particular asset, or support a wider family governance arrangement. Because a purpose trust may have no beneficiaries able to enforce it, jurisdictions that permit non-charitable purpose trust generally requires an enforcer. The enforcer monitors the trustee and ensures that the assets are applied to the purpose stated in the trust deed. The enforcer should be independent from the trustee and should have access to enough information to perform the role properly. The deed should explain the enforcer's power, information right, removal process, and replacement procedures. A purpose trust can become difficult to operate if there is no active person responsible for enforcing its terms. Now let us discuss custodians and banks. A custodian or a bank may hold financial assets and process transactions on behalf of the trust. This does not normally give the custodian the power to decide which beneficiary receives distribution. Those decisions remain with the trustee unless the trust document provide otherwise. A trust administrator may maintain records, prepare documents, organize meetings, coordinate payments, and support regulatory reporting. Lawyers, accountants, and tax advisors may also assist the trustee with particular decisions. These professionals provide advice and administration, but they do not become trustees themselves just because they are involved in the structure. Their authority should be recorded through clear engagement terms, mandates, and reporting lines. This is especially important when the trustee, administrator, custodians, and investment managers are located in different jurisdictions. Now comes the directors of underlying companies. Many trusts do not hold every operating asset directly. Instead, the trustee may own shares in one or more of underlying companies. The trustee acts as the shareholder while the directors manages the company and its daily operations. The directors are responsible for the company's business decisions, employees, contracts, and financial affairs. The trustee exercises shareholder rights, which may include appointing directors, approving major transactions, and reviewing the company's performance. This separation is particularly important when the trust holds an active family business. The trustee should not manage daily commercial operations unless it also has properly defined position within the company. The company directors should not decide how the trust benefits are distributed unless they hold separate roles under the trust. Keeping these responsibilities separate supports clearer accountability and reduces confusion between the company assets and the trust trust assets. Now consider a family trust that owns international companies and diversified investment portfolio. The settlor transfers the assets and records the objectives of the structure. The corporate trustee becomes the legal owner and manages the trust under the trustee. A protector approves the replacement of the trustee and selected major decision. An investment advisor manages the portfolio within the agreed mandate, and the company directors operate the business while the trustee considers requests from the beneficiaries. A family committee may provide information about education, healthcare, or future business participation. The arrangement works when every authority has a clear boundary. Problems develop when several people believe they control the same decision, or when an advisor begins giving instructions without any formal authority. The trust deed should cover decision thresholds, voting procedures, conflicts, access to information, incapacity, removal, and succession for every important role. It should also explain how disagreements are handled and whether a decision requires one person, a majority, or unanimous approval. Cross-border coordination must be considered throughout the structure. The governing law of the trust, the location of the assets, the residency of the trustee and the beneficiaries, the banking arrangements, and the tax reporting obligations may involve several countries. Domicile, residency, and jurisdictions can affect the tax treatment for the settlor, the trust, and its beneficiaries. Where asset protection is part of the planning, timing and intent are also important. A trust established after a claim or dispute has already developed may not provide intended protection. So if you want our help in setting up a family trust for you in any of the international jurisdictions, or would like to explore whether such structures will fit your situation, you can request a personalized asset protection plan by clicking the link in the description below. That's it for today, and I will see you in the next video.